Good morning, everyone. This is Harini, Assistant Professor from BCom General Department. In this video, we are going to discuss about the topic joint stock company. Before going into the topic, first we discuss about the meaning of a company. A company is a legal entity formed by a group of individuals to engage in and operate a business enterprise in a commercial or industrial capacity. So next one is companies may be either a public or a private. A former issues of equity to shareholders on an exchange while the latter is privately owned and not be regulated. A company is generally organized to earn a profit from its business activity. So next we move on to the characteristics and features of a company. In that there are 9 distinct characteristics. So first we will discuss one by one. So, in that, first one is incorporated association. A company must be incorporated or registered under the Companies Act. Minimum number of the members required for the purpose is 7 in case of a public limited company and is 2 in the case of a private limited company. So, second characteristics is legal entity distinct from its member. A company is distinct from its member who constitute it. Hence, it is capable for enjoying the rights of being subjected to duties which are not the same as those enjoyed or borne by its member. Next, third characteristics is artificial person. A company through a juristic person does not possess the body of its nature being. It exists only in contemplation of law. Being an artificial person, it has to be depend upon the natural persons, namely the directors, officers, shareholders, etc. For getting this various work done, however, these individuals only present the companies and accordingly whatever they do within the scope of the authority conferred upon them. And in the name and on the behalf of the company, they bend the company and not themselves. Next one is liability, limited liability. One of the principal advantage of trading through the medium of limited company is that the member of the companies are only liable to constitute towards payment and of its debts to its limited extent. Next one is separate property. Shareholders are not, in the eyes of a law, part owners of an undertaking. In India, this principle of separate properties was best laid down by the Supreme Court. So next one is transferability of shares. One particular reason for a popularity of joint stock companies has been that their shares are capable of being easily transferred. A shareholder can transfer his shares to any person without the consent of his member. Artificial of association, even the public companies can put certain restrictions on the transfer of shares but cannot be all through stopped. So next one is perpetual succession. Companies being an artificial person cannot be incapacitated by illness and it does not have an allotted span of life. Being distant from its member, the death, insolvency, or an retirement of its members leaves the companies unaffected. Members may come and go, but the companies can go forever. It continues even if all its human members are dead. So next one is common seal. A company's being an artificial person, it has its own legal common seal, which is directed by this Companies Act 2013. So therefore, it does not have a mind or limbs of human beings. It has to work through the agency of human beings, namely the directors and other officers and employees of a company. Next, the last characteristics is voluntary association. A voluntary group is a group of individuals who enter into an agreement, usually as volunteers, to form a body or an organization to accomplish the process. So common examples include trade association, unions, learned societies, professional associations, and environment groups. So next we move on to the classifications of the companies. So in that there are various the companies has to be divided into various classifications. So first one is incorporations. So under that there are three subpoints that has three distinction classifications. So first one is chartered company, second one is statutory company, third one is registered company. So next classifications is according to the liability. So in that it is limited by the shares and limited by its guarantee and unlimited company. And the company is further classified on its control. So first one is holding company, second one is subsidiary company, and finally the company is classified into the transferability of its shares. So in that the first one is private company and the public company. So we will discuss one by one. So first one is on the basis of incorporator. There are three companies. The first one is chartered company. If a company is incorporated under the special chartered guaranteed by its march, it is called as a chartered company. This form of organization does not exist in India as there is no monarchy. Bank of England, East India Companies, British Broadcasting Corporations, BBC in short, so etc. These are the example of an chartered companies. So next we move on to the chartered companies of second one is second one is statutory company, a company which is created by the special act of an legislator. It is called as an statutory company. So next one is registered company, a company which brought into existence by the registration with register of an companies under the Companies Act 1956 or either by the 2013 Act is called as a registered company. Next, we move on to the on the basis of liabilities of its members. The first one is company limited by shares. In case of a company limited by shares, the liability of its member is limited to the nominal value of the shares held by him. So next one is company is limited by guarantee. In this company, the liability of its member is limited to such amount as the members may decided to contribute to its asset of a company in the event of its being wound up. Example clubs, societies, trade associations, etc. So next one is unlimited liability. In this case, the members are liable to an unlimited extent in the event of winding up of a company. But this type of companies as they became rare, unlimited companies are found in UK's, Hong Kong, Ireland, Pakistan, etc. So next one is on the basis of number of its member. There are two different companies, public limited companies and private limited companies. Public companies. So public companies means a companies which have been invited to the public to subscribe its shares are called as public limited companies. So next one is private limited companies. The companies which require minimum number of two persons for registration and limits the member of its member to 200 and prohibits an invitation to the public to subscribe his shares and debentures is called as a private company. So next one is one person companies. According to section 2, subsection 26 of an Companies Act defines the Companies Act as a companies that has only one person as to its member. So next one is small company. According to Companies Act 2013, a Companies Act is not a public company. It has paid up share capital less than or equal to 200 crores or not higher amount specified but not higher than 10 crores. Next one is dormant company. A company is called as a dormant companies by which is incorporated at the company's house is not currently carried by any kind of company's business activities or receiving any form of an income is called as a dormant company. So next, on the basis of ownership, so first one is in that government company. The government company means a company in which is not less than 51 percentage of a share capital is held by a central government and not by any state government or government is called as an government company. It is also include the company which is subsidiary of its government company. Example, BHEL, BEL, Indian Telephone Industries, etc. Non-government companies means it is a company whose capital is subscribed from the promoters and investing public. So next, on the basis of its control, first one is holding company. As per the section 4 of a Companies Act 1956, holding company is the companies which control a subsidiary companies. Holding company is a company which hold more than 50 percentage of a nominal value of share capital of another company. So next one is which controls the compositions of board of directors of another company. So next one is subsidiary company. As per section 4, the Companies Act 1956, subsidiary companies which is controlled by the holding company. So companies those 50 percentage of a nominal value of equity share capital is held by the other company. So other companies control the compositions of board of directors. So next last one is associate companies. Associate companies are those in which the companies are significant influence. This significant influence amount to ownership at least 20 percentage of its associate company. The other companies control the exist in terms of its association companies business decisions under the agreement. Association companies can also exist under the joint stock ventures agreement. So next we move on to the memorandum of association meaning. So in short we will call as an MOA. So MOA of an company means a legal statement. So it is a legal statement signed by the shareholders and guarantors when they agreed to form a limited company. So MOA is a document containing the details of a company constitutes and it's the foundations of a company structure. It is known as a chartered companies of a company. It lay down the scope of a company's activities, objectives, and which is its form, determine the scope of its authority and its relationship with the outside world. The creation of MOA is the first step towards a company registration. During the formation of the company, a company members must subscribe to MOA. Subscribing to an MOA means to put an one's mark or signature of the document as attestation or approval of its content. So in that MOA, it's the basic content which should be content in MOA is listed out there. So every company's MOA should contain the following 5 clauses. So namely, first one is name clause, second is registration office clause, third one is object clause, fourth one is liability clause, and last capital clause. So next we move on to the articles of association. So article of association is generally termed as AOA. So AOA of a company contain its rules or bylaw and regulations that controls or govern the conduct of its business and manage its interior or internal affairs of companies. So AOA is subordinate to a MOA of a company and it's governed by the MOA. Every company must have an MOA and it plays a vital role in defining its internal rights, working, management and duties. The content of AOA should be synced with the MOA of the Companies Act 2013. So next topic is doctrine of ultra vires. Doctrine of ultra vires means the term the ultra vires is derived from the Latin word means beyond the power of. Any transactions or activities beyond the scope of the companies or the authority endowed upon the custodian of an companies will come under the scope of a doctrine of ultra virus and can be categorized or criticized accordingly. Thank you.